Well, a very good afternoon to you, ladies and gentlemen, and welcome to the second day of Thai Global Summit 2020, a platform where we get to meet the global leaders and learn from their experiences. Ladies and gentlemen, learning from the masters of their craft is not everyday occurrence, but with Thai Global Summit, that's our goal. All right. So, thank you once again for joining us from across the world. Without further ado, let me go and introduce our next session to you, ladies and gentlemen, which is blind spots of deal flows and exits. And let me go and now introduce the moderator for the same. We've got Jayesh Sanghvi, who's the office managing partner, Ernst Young, Hyderabad. Now, let me hand over the session to Mr. Jayesh Sanghvi, who's going to go ahead and introduce the panelists to us. Welcome, Mr. Jayesh Sanghvi, and over to you.
Thank you, Dhwani. Thanks a lot, and welcome to everybody for this session. And we hope we have a very engaging session. I've got a bunch of co-panelists with me here who are experts in their own field, and let me just take a minute to introduce them. First, let me turn to Monica. Monica, welcome. Monica leads the commercial IP practice at Sai Krishna and Associates, a leading IP law firm. And she has additional specialization in copyright advisory matters, and obviously deals with some of the most interesting trademark and prosecution and legal matters. Also experience across a gamut of sectors. She's also interestingly one of the most highly ranked counsels in this area, and recognized amongst the top 250 across the world women who actually are in the area and field of IP. And she is amongst the 6 from India who actually feature there. And she's obviously an IP star ranked by that particular organization. Welcome, Monica. It's great to have you on this panel.
Thank you so much, Jayesh. Lovely meeting you, and hello, a very good morning to all of you.
Thank you. Let me now turn to Shailendra. Shailendra is the founder and the managing partner of Tattva Legal Hyderabad. And I've known Shailen for many years, and I think 25 years of experience in this field of law. He's obviously the alumni of NLS Bangalore, and also a master's in law from Sydney University. I think Tattva Legal is actually one of the best ranked, regional law firms. It's a full service law firm in the Twin States, and has been providing, services in the area of, law practice, particularly on commercial law, on private equity, investment, corporate structuring, joint ventures, and many more. So I think welcome, Shailen. It's great to have you on this panel.
Thank you. Thank you very much, Jayesh. Good morning, everyone.
Thank you. And last but not least, I'm here as the moderator, so my job is a little easier. But as they said, I'm the office managing partner of Hyderabad. My love is tax, so I actually do tax for a living. And I kind of impinge upon any transactions and the tax related to that transaction. So I hope to contribute my bit in the conversation. I also kind of am a lot of interested in family offices. So I help with the organization, the structuring, succession, and that's an area of interest where I've worked quite a bit with a lot of my clients here. Having said that, let us just delve deep into the matter right now. I think the matter at hand is quite complex, and I think we've been given 40 minutes to address it, which I'm sure it's going to be quite challenging. But we'll try to address some of the most key topics, which should be the top of mind of founders, promoters of the big startups and companies which are in this area. I think it is no different when I look at it that the scale of investment or the life cycle of a company, whether it is a budding startup or it's a mature organization, I think the complexity is no different. Generally, the complexity is the same, and therefore, addressing the complexity at a startup stage is always a big challenge because the resources need to be really rationed. Can't have resources, try to deal with all the complexity while the focus is so much on the business. But having said that, today we'll try to focus on the headline items which should come up in any discussions and negotiations focused on startups and early stage companies, so that we try to make it a little more focused and address that as we go ahead. Let me turn to you, Shailen, first, and ask you as to what are some of the pitfalls that can occur in relation to management of a startup, especially in the context of an investment. So when an investment comes into a startup, how do you deal with that, and what should the promoters know while agreeing to restrictions which can be in any of these agreements?
Sure. So I think the tendency for the promoters generally is to accept whatever terms are proposed by the investors, and management is one of the areas where because of the shareholding held by the investors would want to take control. They may let the promoters run the company, but at the same time they would want to have the legal rights, let's say by way of board seats or by way of veto rights. So some of the pitfalls, I'll just take you through what could be issues that could crop up out of these things. So one, I think best way to talk about this is through recent cases that have occurred in this area. So one of the recent ones is the Indigo saga, where the founders between Rakesh Gangwal and Rahul Bhatia, there was a spat. So while Rakesh Gangwal held a 37% stake approximately, and Rahul Bhatia held a 38% stake, the shareholders agreement and the articles of association of the company gave uneven management rights to Rahul Bhatia. So he had the right to initially to appoint 3 out of the 6 directors, while Rakesh Gangwal Group had the right to appoint only 1 director. So when Gangwal Group felt that the company is not being managed properly, there are related party transactions that were hurting the company. They wanted to fight it out, and I think that resulted in a spat, and they were not able to regain management control, though they were 37% stakeholder, almost equal to the Rahul Bhatia Group. That has resulted in a dispute which is currently pending before the London Court of International Arbitration, and it's also before SEBI. So yeah, that's letting go of board seats at the initial stage when the company was being found led to this, and when the company grew up and reached this stage. One other instance is currently the dispute that's going on between Amazon and Future Retail. So when Amazon invested in Future Coupons last year, it actually took over a whole lot of veto rights. It was given veto rights, including right to veto transfer of any assets or business of Future Retail, and this was an indirect way of controlling Future Retail. And when because of the COVID situation, Future Retail and Future Group went into bad place financially, and when they were looking at selling out to Reliance Group, Amazon was able to get an order from the Singapore International Arbitration Center to block this. I mean, dispute is still underway, but it was able to block. So veto rights and board seats obviously are fairly important, and they need to be looked at very carefully when you're agreeing with the investor.
Thank you, Sailen. Thanks. I think, Monica, my question to you is that IP as a subject is a very underserved, kind of area in particular early stage companies. And I think even in mature companies, I think we see, various areas not really being addressed from an IP standpoint, where sometimes they remain so very core to that organization. So what do you think are the pitfalls? Initial stages where, typically IP-centric organizations, which are going in for this, are there specific areas they should focus from an IP perspective as to how to protect and how to ensure that it doesn't come in the way?
Jesh, in my assessment, what we see usually is very similar to what Shailendra has been highlighting in the context of management. The principle logically applies squarely to IP as well, as you would expect. So from any investor's point of view, of course, owning the IP from day one is their dream. And that's what they are really investing into more often than not, right? Particularly, of course, in IP-centric. Of course, I'm focusing on IP-centric companies in the first place. Now, whether it is different industries, whether it could be an invention, and we could be talking about a patent, or whether it is a media house where you're talking about whatever works they have created, whether it's an audiovisual company or an audio-owned company, etc. But effectively, the first pitfall that any promoter should be thinking about very carefully is how you are giving up the ownership of the IP at different stages. And of course, beyond a point, it's almost impossible for a promoter to say, hey, this is not something which I'm going to let go of. But then, typically an investor would turn around and say, then what am I really investing into? Having said that, there are ways to make sure that through the life cycle of the investment, how you can break up the control in a manner where you could look out to have some kind of measures which would help you to protect yourself as a promoter, whether it is at what stage, what type of IP would be exploited, the investor would have access to. Then, of course, there are measures in terms of, and if I would take a step back from an investment point of view, the first stage, IP protection and identification of IP in your company itself. We find that at many stages, and in fact, in most cases, unfortunately, startups are unable to identify the IP, let alone protect it, which comes later. By the time they genuinely understand the worth of what they have created, it's almost too late because the investors already in with their set of lawyers who have already assessed what's the good, where's the meat, and they found a way to take it away even before you could understand the value. And it could come down to being experts in your field. Jesh, you and Shailendra would have seen for years together, the biggest struggle has been, how do I value my IP? The valuation of IP itself is an uphill task. So, and again, the nature of the IP sometimes helps you to assess it quickly, and sometimes it's lost on the best of companies, right? From a trademark perspective, the goodwill lies in the trademark, what you have been using. Now, if you are a startup, a lot of people do not put a lot of value in the identification of their own business. And as you go along, that's where the most value sets in. Now, in terms of patents or in terms of copyright, confidentiality, these are kind of things which we all talk about it all the time. But when it comes to honestly seeing it through while going and talking about your, the dreams that you have as a promoter for your company, most often people put this aside and say, let's get the work done, we'll do all of this. NDAs are not taken seriously. Patent inventions which take years together to put together are put to waste because before discussing the idea, no one has bothered to file a patent application. The biggest pitfall being that once it's out there, you lose protection. So there are these, some very, very basic steps in identification of IP, protection of IP, and then thinking about that when I have a partner, how do I maximize the strength of what I own? So, on a very on a very high level, I would think that these are the three very clear steps. And before venturing into, my 2 cents are, before venturing into a due diligence in the hands of the investor, make the effort of going through an audit yourself. A self-audit is the key to ensuring that when the investor is already inside your house, you know your worth and you know how to protect that worth.
Thanks, Monica. That's a very well said point, and I think I agree with you that in my experience, I think companies, particularly startups, sometimes don't seem to really think of it ahead of time, and the risk of cannibalization, the risk of losing actually the core and the soul of your organization is pretty high. So I think there's bound to be time and money well spent, like you invested in your organization. I think investing in doing a self audit is probably equally and more important before you get somebody else in the house. Let me just switch to a particular tax point, which I think has hogged the limelight of the tax world. Particularly on startups, is basically the angel tax. Now, the angel tax is a common terminology for whether the investment which comes into a startup, if it does not meet the typical valuation thresholds, and if the investment is at a much more higher valuation than what can be justified, can the capital investment itself be treated as income in the hands of the startup, which is like you pay tax on your capital which you received from an investor. And I think this has been a big problem. There's been a lot which the government has addressed since 2019 February, where they clarified through a press release, and then after that, through a particular notification, and thereafter even the law got amended in the income tax law. But there still remains a lot of dissonance in what the clarification in the press release states and what the law basically mentions. And the dissonance comes from the fact that, while the original clarification in the press release talked about including AIFs and others in the 25 crore threshold, which they announced, whereas when the when the actual notification of the DPI TIPP came, it did not include AIFs, and they just included venture capital undertaking in VCFs. Now, VCFs are only one part of an AIF, right? AIF Cat 1 only has one segment or subsegment, which is VCF. There are many others. The Cat 2 is not included in that. And, when the law was amended, while it included Cat 2 and the others, but it did not include in such a way that it would be considered for the purpose of the 25 crore threshold. So I think there are some areas which still need some clarification. It is important that, these gaps are addressed, and that's more from a policy standpoint. But for the companies, it is equally important that, you have to watch out, right? Because this actually sits on shares. So if you're getting investments, anything other than shares, like convertible instruments, which are not shares, then this does not hurt. So therefore, we'll see mostly that your convertible debt as the investment structures in the early stage to ensure that the angel tax issue does not come into play. But this is something which you need to really clearly watch as a startup. You don't pay tax on the capital which you received. Sorry. Let me turn to you, Shailendra, now. This one particular thing which again hurts a lot is the anti-dilution.
Sure.
Founders are really concerned with the dilution which happens as they start getting different rounds of investments.
Right.
What is it that you need to be watching out for?
Right. So investors typically, especially the early stage investors, they do not want the valuation at which they come to go below as new rounds of investment comes in. So we have, dilution again is one of the provisions which needs to be negotiated very carefully. We have all the technical terminology of full ratchet, half ratchet, etc. But let me give you an instance how it has impacted. Let's look at Redbus, for instance. So when Redbus initially got investments, they had agreed to a full ratchet dilution clause with the investors. In fact, they actually signed up the documents by themselves without consulting any lawyers or other advisors. So the investor actually, whenever any new round of investment came, they continued to retain their shareholding percentage. So for instance, if they came in at, let's say, 1 million investment for a 15% stake in the company, whenever further investment came in, they continued to retain that 15% holding or whatever is the percentage without putting in any more money. This actually led to dilution of the promoters. I think as on date, when they were looking at recent sale to IBBO last year, I think the promoters got diluted down to 15% solely because of this anti-dilution clause which the investors were able to put in. So I think again, this is one of the things. We do have restrictions under foreign investment regulations which could act as some sort of protection, but it needs to be looked at what kind of dilution rights are being provided to investors, and promoters do not take the brunt of ensuring investor stake or percentage shareholding is maintained.
It's actually quite counterproductive, right? If the founders lose interest in the business, then I think everybody loses value, including the investors. So I think it's a balance which I think needs to be met both by the investors as well as the founders to ensure that while the value keeps increasing, the value is shared, but something needs to be allowed for the founders who actually they have looked at it as their own enterprise where they've allowed others to come in to be a little more cooperative about it rather than actually try to look at control as a different measure from sharing the value. So I think that's a great point, Shaili, and a great example. And I think, Monica, I think even IP, right? I've seen in many instances that IP probably somewhere is, as you rightly said, is probably not really, kind of identified at the right stage. And it is also not sure where it sits, whether it's at a different stage from where the investment has been made. And, how does how does that get addressed in typical investment agreements as well?
So, Jayesh, you raise a very important question, and particularly, when we were touching upon trademarks. So, for example, in the very beginning and at the very outset, when startups set up their house, the first thing they do is file for a trademark application. That's pretty standard. But at that stage, mostly everyone files the trademark application in the personal name of the promoters, right? And that's where it all begins. In terms, the complications begin, and that's where we always look at tax advisors like yourself to tell us, now what do we do with the investments coming in, where, how do we make these trademarks move? What was the goodwill? Will the money go to the promoter? How should we ensure that the value actually sits in the company and not the person? And then there are these complicated agreements where we try to sort it out, where the promoter then assigns all the marks to the investment vehicle, and then we have complications on tax, so on and so forth. Long story short, if there would be a first measure of ensuring that you house your IP where you feel the investment is going to come in, and you protect it from day one. So it's not only about ensuring that the marks should be filed in the name of the company, but also making sure that the relationship between yourself and that company, howsoever you want to structure it. Now, for example, and I'm going to be almost contradicting myself. There are promoters who I have met and spoken of it very, very closely, that look, this company is nothing but me. And that happens a lot in, where very seasoned individuals set up a startup. It may be a startup, but these are seasoned individuals in the industry, well-respected individuals who know that it's not the company where the worth is, it's the person. It's a person-driven business. Mostly, if I was to think about it, look at if tomorrow, for example, Dr. Prannoy Roy was to set up a company, right? We all know it's the company, it's not the company, it's Dr. Prannoy Roy who is where the value would sit. So how would you structure in an example such as that, or any individual like that who holds all the strength? How do you structure the relationship of the IP, the worth, and that company, which for all practical purposes is worthless without that person, right? Would you set up a licensing arrangement where you would protect the name and the personality such that he actually gets the worth of his money? But at the same time, the reality is that even if it is a one-person driven business, ultimately, very quickly, there are participants who add value and now want to derive that value and at some stage walk away. So there are these complex situations, and there are no perfect responses to this. If I was to talk without understanding the context of facts, my first answer would be house everything in the company. But if someone was to tell me that, look, it's not about the company, it's about me, then I would say, house it with yourself. But again, not without speaking to advisors, not without understanding what it would mean for you to work with that same strength qua a company, a lot, and particularly tax advisors and corporate advisors, because without understanding how you're going to be able to extract that money, it's worth nothing. You may as well, you may at the end come to the a point where you would think back that I wish I had just housed it at this without understanding what you are doing from your tax advisors and so on and so forth.
Thanks, Monica. I think you raise a very pertinent question on the heady combination of emotions, ownership, control, and I think this is a perfect recipe for a lot of challenges. And I think the tax is a big consequence and issue which actually stares at people and really hurts from a cash flow standpoint if it is not really housed in the right place. And I think I've seen a lot of situations, also as you referred to, on individuals become very, very important for an IP centric organization. And how do you kind of bind the individual to the organization? Because the investors want to ensure that, the individual is bound. Now, individual brings in value, which is for services, and value, which is also for the broader IP, which he kind of contributes. Segregating these two is a challenge. And then there are handcuffs which are put that you have to be there for so many years, even if a transaction happens, that is a problem as well. And there are issues with deferred consideration, right? Can you really defer a consideration beyond a particular point in time, particularly when you have, people involved with, foreign investors come in? So, how much can you defer? And, while deferral may be a potential possibility theoretically, it has a very concocted tax question and a tax answer to it, because, tax is all at the point in time of transfer. Then can you attach contingency to it? So you can defer it, maybe, but can you put it contingent? Maybe not, if in certain situations. So I think these are truly very, very relevant points which you raise, Monica, when you articulated that. And I think the other thing which happens as you go through this whole journey of dilution is that, and we've seen in startups that, startups are not measured in terms of, the value of a startup is not really in what profits is generated at times. And in most instances, the newest startups are the ones where we develop a particular property or an IP or something, and they may still be generating losses. Now, losses from a financial standpoint, again, to a point, are really good assets, because they actually give you a shelter against your future profits. Now, there is a very clear law within the Income Tax Act, again, which kind of, gets the losses can get completely vanished if there is a substantial change in the shareholding. Now, again, this was to a certain extent addressed in, whenever the startup, questions came up before the government, and they addressed to a certain extent. But they say that in the first 7 years, if the year in which you made losses, if all the founders, the original shareholders of that year continue in the year in which the losses are proposed to be set off, then the losses will become available. Now, this is not enough. Most of the times what happens is that, while the controlling may have changed, some of those original shareholders may not have remained, because, startups don't have cash, right? So they would have paid through shares to employees through an ESOP or something. And the ESOP could have changed hands because the person moved on. So I think this is one area to watch out, because, you can suddenly have this, losses kind of vanish. You may have, factored them as some assets against your future profits, but they may potentially vanish. So that's an issue. And maybe there is a reason why, people also have a two-layered structure in some instances, because, you retain the original entity always at 100% through another entity. And that entity is actually where you all have all the agreements to make sure that all the shareholding changes probably do not impact the actual operating entity. But all this requires some level of, attention to this detail, and maybe early on rather than later, to ensure that you have protected most of this. So this I think, is a great point. I think all the startups, whether they're early stage budding or they at a particular stage, need to really watch out for. I think the benefit that they get when they get some very serious investors, that they get the benefit of them bringing in a lot of, these people to come in and help the startup now to start thinking of it a little more structured way. But sometimes it is too late, because they're at the negotiating, they're receiving end of the negotiating when they're negotiating with their investors. So I think it's a catch, right? Whether you should do it yourself or you should wait to do it when, you get to a particular stage. But yes, I think there's never too late to get this, done. Let me turn to you, Shailen, now. I think, I think this whole thing, and maybe let me come to Monica, you first, because I think this is really on the IP side. There is this whole, urge by companies to really get, I think the question is that whether IP protection laws are better in India or they're better overseas, right? And, always we hear that, no. And again, there's a pressure also from the investor community. Can we have a holding company outside? Can we all own through overseas? Because there's better, other commercial factors around it. But to this question on IP laws, better in India versus overseas, because all the IP gets generated here, and you want to really hold it from outside. Is that, what's your take on that?
So personally, I think my constant take on this point is that there are no lack of laws in this country. In terms of protection of the IP, we are equipped to handle just about any form and in a very efficient manner. Now, even if you were to seek protection or hold the IP outside of this jurisdiction, it wouldn't really matter beyond a point, because you would go through the loops of ensuring that the same IP is protected in India as well, because in some cases in IP, the protection is territorial in nature. It doesn't matter. You can't just say, for example, you can't say I hold a trademark, so I hold it worldwide. Trademark rights itself are territorial in nature. So you need to. It's another matter that you may have rights from by virtue of use, but at the same time, to to get the statutory grant, you need to file the trademark application within this jurisdiction, even if you have registrations in 100 other countries. So, from a protection point of view and from the law's point of view, to answer your question, we are very well equipped. Again, the reason why this run for let's go outside of the country and let's hold it from outside are often questions which we as IP advisors look at people like you and Shailendra to guide us on. That do you see that value somehow? Because from an IP perspective, we don't end up seeing much value in terms of taking it outside. In fact, I'm sure Shailendra, you'll chime in on this. There are restrictions when IP generated in India needs to leave the shores of India. There are permissions that are required, then there is a certain amount of money which can go out, post which you need certain amount of permissions, and then there are restricted sectors, so on and so forth. Right. So from those perspective, again, we look at corporate counsel in terms of understanding that what are the restrictions, what are the industries that you are in. But from an IP perspective, you're good to go, housing your IP very much here.
Thanks, Monica. That's a great answer. I've never got such clarity, because I think I've always got confused with this. But thank you for that. I think you're basically saying you should be agnostic from an IP standpoint. You generally look at it more from. So, Shailendra, over to you. I think Monica did mention this. Flipping the structures, right? What are all the issues around it?
Sure. I think the biggest issue is, as you know, round tripping. So while the Indian laws do not really provide for round tripping, it's the Reserve Bank of India that gives this interpretation that round tripping is prohibited. And this was the stand taken by Reserve Bank of India from last 2 decades, if I remember correctly. And I think recently on the frequently answered questions, for the first time ever, they have put in a clarification that this kind of structure, which entails entity which is set up by Indians, an Indian-owned entity making investments back into India, is something that is prohibited. That's a clarity that's been given on Reserve Bank of India website itself. So that's, and there are also, I mean, if the decision to externalize or to set up a holding company is not taken in the initial stages, I think probably from a tax perspective, we'll talk about it in more detail. But from a legal perspective, from again getting approvals from Reserve Bank of India for swap of shares becomes very complicated. Especially if the company has gotten some value over a period of time. And yeah, I think these two are the key factors that I could think of. But yeah, what do you think from a tax perspective? How does that?
It's a fairly complex, and I think you raised the right point, Shailendra, that it's the stage at which you decide to do this makes a big difference. Because there could be fair bit of complexities around transfer pricing, valuations, how do you take it out, tax outflows because you do that. And I think you have to have a real commercial justification to doing it. And it should not really be tax motivated. Let me put it very out, clear. And I think the other aspect also is that if the overseas entity which you set up is is a overseas holding company, you also have to be very careful about where is the effective management of that company, right? It cannot again come back to India. Then I think you kind of give away whatever not so perceived advantage you have of creating that entity. So I think these two aspects, from a tax, from a transfer pricing, taking it out, plus I think the fact that we need to ensure that the management and the board seat actually sits there to ensure that it is independent entity. Now, obviously, I'll have the investor agreements and everything there, and I'm presuming that from a commercial, investment agreements and other things, you actually have more flexibility compared to what you may have from a corporate legal standpoint in India, how to stitch up the agreements and protections and rights as well. I think the other aspect which I've seen is that, and to your point which you mentioned, from a FEMA perspective, Reserve Bank has been quite open of late. I think they have actually considered some of these applications. They have approved them to a certain extent based on commercial considerations. Obviously, with questions and restrictions and other things which they have put out, saying that these needs to be followed for you to be able to do this kind of a structure. But I think it's possible. I think the other interesting fact which has come up is that while India has now opened up, at least conceptually, while the rules and everything will come out, for Indian companies to list overseas without listing in India, and which kind of is another thing which actually is gaining a lot of momentum. But but to the point that, does that still give you the same advantage of having the entity overseas? Because from a legal commercial standpoint, having an entity overseas still probably scores than having an Indian entity listing overseas. So I think while the end state is good, but the journey to that end state could actually be very different depending on where we stand. And we've seen many structures, obviously, some of the big exits of unicorns and other things which happen in India, without naming any of them, they've happened through structures which have finally evolved to be a holding structure overseas. Therefore, any startup in the early stage through its journey is always looking at that end state and saying that should I do it now versus should I do it later? And the the cost benefit of actually maintaining an entity overseas, the cost of doing it, and obviously it's not cheap, right? You have to incur the legal costs there, you have to incur the compliance costs there, you have to ensure that the entity is maintained well. So I think that always has pushed the decision to a stage where the tax question of flipping becomes a bigger concern at that stage versus, then you look back and then most of the promoters and founders would say, no, I probably could have done it earlier, but then earlier you won't have done it because you didn't have that level of flexibility. So it's a catch-22. But I think this question has always, hogged the limelight. I think, we almost close to the time. And I wanted to check, Dhwani, if, we'll get to a close. Are there any questions? We probably have overshot the time by, 3 minutes or so. Arun? Okay, so I think we are good. I think we may not have questions, but if there's anything from the participants, please do write in, and we'll be happy to kind of help and support. And I really thank you, Monica and Shailen, for making this time. And I'm sure all the members who attended, plus the participants, they would have really found this useful. Thank you so much for your time, and have a great rest of the day. And do join us at the TGS 2020. As and go through all the sessions. Thank you so much. Thanks a lot.
Thanks,
Thank
everyone.
you.
Thank you.
Thank
Have a
you,
good day,
Jayesh.
everybody.
Thank you, Sharon.